Can appeals against sedition convictions proceed despite the Supreme Court's stay on Section 124A? This question pierces the heart of a decades-long legal debate that echoes the struggles of a past defined by colonial oppression and continues to challenge our democratic principles today. Section 124A of the Indian Penal Code was introduced in 1870 under British rule, a time when laws were crafted to suppress dissent and silence voices that dared to challenge authority. Historical records remind us that figures such as Bal Gangadhar Tilak and Mahatma Gandhi once faced convictions under this very provision, demonstrating its use as a tool of political repression. Over time, however, legal interpretations evolved, and courts began to see a need to balance the state's interests with the rights enshrined in our Constitution. This evolution sets the stage for today's legal conundrum. In May 2022, the Supreme Court of India suspended all pending trials and proceedings under Section 124A, an order that halted sedition cases and allowed for a thorough reconsideration of this colonial-era law. At the center of the current debate is the pressing question: should appeals against sedition convictions continue even while the statute remains in legal limbo due to the stay order? The case of Safdar Nagori, imprisoned for 18 years following his 2017 conviction under Section 124A, brings this conflict into sharp focus. His prolonged incarceration and the deferment of his appeal by the High Court highlight the inevitable clash between legal procedure and judicial caution in the wake of a stay order. The suspension of proceedings under Section 124A has triggered varied interpretations among legal experts and scholars. Some argue that the stay order creates a judicial vacuum, preventing lower courts from rendering decisions on appeals in cases already under deliberation. Others contend that allowing such appeals to proceed would undermine the authority of the Supreme Court's directive and risk reopening wounds from a bygone era. Each perspective holds weight, and the tension between protecting individual rights and upholding judicial authority defines the current legal battleground. We must ask ourselves, what is the balance between the preservation of legal precedents and the evolution of democratic values? Looking deeper into the issue, it becomes clear that the controversy over sedition laws is more than a dead letter in legal texts. It is an enduring question of how a nation deals with dissent and champions free speech. The Law Commission of India's 2023 report proposed modifications to ensure that sedition laws do not enable misuse by authoritative powers, urging a shift towards legislation that upholds contemporary standards of justice. Meanwhile, the recent proposal under the Bharatiya Nyaya Sanhita to replace Section 124A with Section 152 introduces yet another chapter in the struggle between ensuring national security and protecting individual liberties. This proposal has stirred debate among legal professionals who see it as a potential means to better align the law with modern democratic ideals, while others fear it might curtail free speech in unforeseen ways. Today, we stand at a crucial junction. The Supreme Court, expected to soon clarify whether its 2022 stay should preclude high courts from hearing sedition appeals, faces the monumental task of reconciling legal history with contemporary values. The anticipated clarification carries significant implications. It may offer closure to long-standing legal uncertainties, bring relief to individuals like Safdar Nagori, and importantly, reaffirm our collective commitment to justice in a society that values both order and freedom. This moment in legal history is as charged as it is pivotal. In conclusion, the legal debate surrounding sedition convictions and appeals remains as relevant today as it was in the colonial era. The evolution of legal interpretations, coupled with the Supreme Court's forthcoming clarification, invites us to re-examine the delicate balance between state authority and individual rights. Our legal system's ability to adapt in the face of historical legacies and modern challenges is a testament to the enduring spirit of justice. Stay informed on the evolving legal landscape surrounding sedition laws and their impact on democratic principles.